In this lecture, we would like to discuss another important doctrine relating to the relation between the judiciary and the legislature, and that is the doctrine of prospective overruling. So, before discussing the very development and origin of the doctrine of prospective overruling, we would like to discuss the previous theory that was prevalent in England, and that was the Blackstonian theory of jurisprudence. And that very Blackstonian theory of jurisprudence, where courts did not have the power to create new laws but could only follow, interpret, and expound the existing laws. But there was a revolutionary change in English jurisprudence by the development of analytical jurisprudence or legal budgetism, which developed due to the contribution of John Bentham, an English jurist and legislative reformer, and his disciple John Austin, who clearly propounded the very theory of analytical jurisprudence and legal budgetism by discarding the Blackstonian theory of jurisprudence, which was prevailing in England, and due to the colonial rule of United Kingdom or England, the Blackstonian theory of jurisprudence was also in some extent was prevalent in the colonial countries, and in particular in United States of America. But gradually the American jurists, they developed this doctrine of prospective overruling. So it was first recognized in America in early 1900. So in that connection, we would like to discuss an important leading case. So the very doctrine of prospective overruling, as we found it rooted in American jurisprudence. So an American jurist, George F. Canfield, has stated that the doctrine of prospective overruling is the duty of a court to recognize and propound a new rule if the court deems that the old rule has become unsound or has lost its effectiveness in the modern day legal regime. So, the American Supreme Court, in the leading case, Great Northern Railway versus Sunrust Oil and Refinery Company in 1932, adopted the very doctrine of prospective overruling for the first time. And in this particular judgment, the court observed that while overruling a previous decision of a previous law, the court is empowered to give its ruling a prospective effect. The reasoning given by the court for adopting this doctrine is that no party should suffer because of the change in law or stance of the court. For example, if a ruling is being given retrospective effect, all the transactions that occurred under the old law would be deemed to be void. Therefore, to avoid such an effect on the earlier transactions, it is necessary that the ruling of a court should be given prospective effect. So, we'll go to the judgment delivered in another important leading case relating to prospective overruling is the Chicot County Drainage versus Baxter State Bank in 1940. The USA court at Hughes held that the actions or transactions that had taken place under legislation that had been declared unconstitutional should not be affected by such unconstitutionality. The transactions in the past cannot be affected or erased by pronouncing a new judicial ruling in that regard. Also, we would like to discuss another important judgment of the Supreme Court of United States of America in the leading case Giffen versus Illinois in 1956. The Supreme Court of America held that the court is not bound to follow the either or approach while determining the constitutional validity of a case. They can opt to approach the case in a manner they deem fit and pronounce a ruling with a prospective effect. So now we'll go to the very development of prospective overruling in England. So in that case, we would like to discuss the practice statement of judicial precedent of House of Lords in 1966. So the House of Lords in practice statement judicial precedent 1966 observed that the Blackstonian theory does not pass the test of time and the courts are empowered to modify and depart from existing laws and decisions if it deems fit to do so. So, in the very leading case, Milangas versus George Textile Limited in 1976, the House of Lords observed that the traditional Blackstonian theory does not pass the test of time while dealing with a claim for liquidated damages. The House of Lords held that the application of the doctrine of prospective overruling would not affect any past transactions, but will only affect the future transactions from the date of its judgment, and in case of its application in India we would trace the very important leading case, IC Goloknath versus State of Punjab in 1967. The Supreme Court in this case laid down multiple guidelines for using the doctrine of prospective overruling. These guidelines were followed as a precedent, and the doctrine was applied by the Supreme Court multiple times over the year. So, we would like to discuss in detail the judgment delivered in this important leading case, IC Goloknath versus State of Punjab in 1967, where the very issue was involving the Punjab Security of Land Tenures Act 1953 and its relationship with Article 13 of the Constitution of India. So, the very case, the very facts of the case that we would like to discuss here is that both the petitioners and their families were the owners of over 500 acres of land situated in Jalandhar, Punjab. However, after the enactment of the Punjab Security of Land Tenures Act 1953, the government issued a notice to them stating that they could only keep possession of 30 acres of land each and had to give up the rest of the land. The land that was to be given up would be deemed as surplus land. Due to this, the constitutional validity of the enactment was challenged on the grounds of violation of the fundamental rights like the right to acquire and hold property as provided under Article 19, Clause 1, Subclause F of the Fundamental Rights of Part 3. So also right to equality and equal protection before the law as provided under Article 14 of Part 3 of the Constitution. So also right to practice any profession as provided under Article 19, Clause 1, Subclause G of the Fundamental Rights of Part 3 of the Constitution. So, now we'll go to the very issue relating to this important leading case, whether the Parliament has the power to legislate upon and amend the fundamental rights guaranteed to the citizens of India under the Constitution. So, the very observation regarding the application of doctrine of prospective overruling and regarding the very objections raised against the doctrine is that there is no evidence regarding the application of the doctrine of prospective ruling on decisions regarding amendments of ordinary laws. Only decisions regarding constitutional law amendments can be subject to this very doctrine. And the second objection that was raised, Indian jurisprudence follows a precedent-based system. It would not be advisable to shift from this approach and adopt an international doctrine such as the doctrine of prospective overruling. So, another objection that was raised, according to Article 13 of the Constitution, any law that is in violation of fundamental rights would be deemed to be void to the extent of the violation. As regarding to this, we would like to refer the ruling of another important leading case, that is Dipchand versus State of Uttar Pradesh in 1959. The Supreme Court held that any law which violates the fundamental rights guaranteed by the Constitution is a stillborn law. Thus, any law that has been declared unconstitutional should be deemed void from the moment of its enactment, and therefore the doctrine of prospective overruling would be against the guidelines set under Article 13 of the Constitution. And after all these objections raised against the doctrine of prospective overruling, the Supreme Court made some pronouncement, such as the Supreme Court initially pronounced three essential conditions that were necessary for invoking the doctrine of prospective overruling. And the conditions have been enumerated as the doctrine of prospective overruling can be invoked only in cases that arise regarding the interpretation of the Constitution. And secondly, the doctrine of prospective overruling can be applied only by the Supreme Court and not by any other high court in India. And the third one, that the court may modify the aspects of prospective application of its ruling in accordance with the justice of the cause or matter before it. So, by applying the aforesaid conditions, the court came to a conclusion that if it follows the principle of retrospective overruling, it would create chaos and will affect several transactions that were carried on under the old regime. Thus, the doctrine of prospective overruling will be applicable in the present case. And in the last observation and pronouncement made by the Supreme Court in this important leading case, IXth versus State of Punjab, the constitutional amendments already in place would not be affected by the decision of the court. Only future amendments would have to follow the ratio laid down by this court in this case. And now we'll discuss another important leading case, and that is Vaman Rao versus Union of India in 1981. The very fact of the case was relating to Maharashtra Agricultural Land Ceiling and Holdings Act 1961, and now we'll discuss the very brief facts relating to this important leading case. So, in this particular case, Vaman Rao versus Union of India in 1981, the Maharashtra Agricultural Land Ceiling on Holdings Act 1961, which imposed certain ceilings on agricultural holdings of the people in the state of Maharashtra. The act was placed in the ninth schedule of the Constitution, which was inserted under the First Amendment Act of 1950 to the Constitution of India. Over 2,000 petitions were filed challenging the validity of the Act in the Bombay High Court. The High Court held that the provisions of the Act cannot be challenged on the ground that the Act was included in the ninth schedule of the Constitution. Thus, an appeal was preferred to the Supreme Court, and the Supreme Court, in its decision, held that the inclusion of an act in ninth schedule of the Constitution does not bar the court from applying the doctrine of prospective overruling. And secondly, although the act is being declared unconstitutional, the transactions under the act would remain valid due to the application of the doctrine of prospective overruling. And now we'll go to another important leading case, and that is relating to Union of India versus Muhammad Ramjan Khan in 1990. The Supreme Court objected. Before that, we would like to go to the brief facts relating to this particular leading case. So, here, Article 311 of the Constitution was amended by the 42nd Constitutional Amendment Act in 1976. Under this new amendment, a delinquent had lost his right to obtain a copy of the inquiry report of his disciplinary proceedings. As for example, now a delinquent could be dismissed without showing any cause for dismissal. The amendment was challenged on the grounds of violation of Article 14, which deals with right to equality, and its violation of the principle of natural justice. So, the Supreme Court held that every person has the right to know the reason for which the person has been suspended from an assigned post. Passing an order without reason is a violation of the principle of natural justice. So, therefore, the amendments is unconstitutional, and the orders that were issued under this amendment would be deemed void, and fresh proceedings will have to be initiated in a proper manner. So also the Supreme Court observed that the courts, while applying the doctrine of prospective overruling, held that from the date of this judgment, no order can be issued by anybody without providing reasons for the punishment that has been provided under the order. So now we'll go to another most important leading case relating to the doctrine of prospective ruling, and that is Odisha Cement Limited versus State of Odisha in 1991. The very fact of this case is relating to Odisha Sex Act 1962 and the rules made thereafter regarding this act. Also certain other acts relating to Bihar, Madhya Pradesh, etc. So, the very fact of the case is that the applicant SAC has challenged before the Supreme Court the constitutional validity of the levy of cess based on the royalty derived from mining lands by the state of Bihar, Odisha, and Madhya Pradesh, being beyond the legislative competence of the state legislatures. further a claim for a refund of the cess or royalties that was collected was made by the applicant assessee. The laws in question in this particular leading case were the Odisha Cess Act 1962 and the rules thereunder. So the Bengal Cess Act 1880, the Madhya Pradesh Upkar Adhiniyam 1981, Madhya Pradesh Karadan Adhiniyam 1982, and the Madhya Pradesh Mineral Areas Development Cess Rule 1982. So, in this important leading case, as previously held by the Supreme Court in India, Cement Limited versus State of Tamil Nadu in 1989, that if an act is declared to be unconstitutional and certain amounts are collected under the provisions of the said act prior to it being declared unconstitutional, the state is not liable to refund the same. So the Supreme Court held that the doctrine of prospective overruling expressly indicates that the ruling of the court should be given a prospective effect and not a retrospective effect. And lastly, the Supreme Court pronounced that since the enactment has been declared unconstitutional, only the cess and royalties that would be levied from the date of this order is subject to refund. The cess royalties levied by the state prior to the act being declared unconstitutional is not subject to refund. And now we'll discuss another most important leading case, and that is Harsh Dhingra versus State of Haryana in 2001. The very issue of this important leading case was Section 30 of the Haryana Development Authority Act of 1988. So, in this particular leading case, we'll go to the very brief facts relating to this case. As Section 30 of the Haryana Development Authority Act 1988 was challenged, absolute power was bestowed on the Chief Minister of Haryana to allow plots at his own discretion. This discretion was to be free from any form of judicial scrutiny. This law was challenged on the ground of arbitrariness and violation of Article 14 of the Constitution, which clearly and expressly provides right to equality and the very principles of natural justice. So, by applying the very doctrine of prospective overruling, the Supreme Court held that in attempting to avoid opening of settled issues and to prevent multiplicity of proceedings, the doctrine was applied. It also helps to avoid uncertainty and avoidable litigation. And secondly, the Supreme Court pronounced that, however, it is pertinent to note that all transactions that take place prior to the declaration of law as unconstitutional or validated under this doctrine in the larger public interest. And the third pronouncement in this important leading case is made by the Supreme Court that subordinate courts are duty bound to apply the prospective operation of law as set by the superior courts in any matter that is placed at their disposal in future. And lastly, Supreme Court pronounced that prospective overruling is not only a part of constitutional policy but also an extended facet of state stare decisis and not judicial legislation. So, these are the important landmark judgments that we found in relation to the doctrine of prospective overruling. And now we'll go to the very conclusion of the very doctrine of prospective overruling. Simply, it means that the decision of a court will have a prospective operation and will not affect any transactions that occurred before the judgment has been passed by the court. The essential conditions that have to be followed while applying this doctrine are that first one, it should be invoked only in cases that arises regarding the interpretation of the Constitution. And the second one, it should be applied only by the Supreme Court. And lastly, the court may modify the aspects of prospective application of its ruling in accordance with the justice of the cause or matter before it. This doctrine is an important part of the legal jurisprudence that developed in India due to the effort of the judges of the Supreme Court or the apex court in the important leading case I.C. Goloknath versus State of Punjab in 1967, where the very Punjab Security of Land Tenures Act 1953 was challenged, and how it relates to Article 13 of the Constitution. And that was the important ruling that laid the foundation of the doctrine of prospective overruling in Indian jurisprudence. And it ensures that public interest is not affected by invalidating past transactions under laws that have been declared unconstitutional. So, those laws which were already declared unconstitutional and those laws which relates to past transactions under those laws enacted before the pronouncement of any judgment relating to doctrine of prospective overruling would not be affected. Such transactions which were made in previous before the pronouncement of the doctrine, so all such past transactions under any laws before pronouncement of this doctrine of prospective overruling would not be invalidated. It would have its operation. So, the very doctrine of prospective overruling, that how it made an end to the Blackstonian theory of jurisprudence and how it developed in United States of America and how it gradually entered into English jurisprudence and ultimately how the very doctrine of prospective overruling was applied by our Supreme Court, especially in the first important leading case, that is I.C. Goloknath versus State of Punjab in 1967, which was a milestone in the history of Indian jurisprudence regarding doctrine of prospective overruling.